Tort immunity represents a complete bar to liability, fundamentally different from standard affirmative defenses like comparative fault. While a defense excuses liability after a wrong is established, immunity shields certain relationships or actors from liability entirely, regardless of the facts of the tort itself. These doctrines are rooted in historical policy considerations, often concerning family structure or governmental authority. This video will analyze three core areas where immunity historically applied. First, we examine interspousal immunity, followed by parental immunity. Finally, we address sovereign immunity, which concerns governmental entities. It is crucial to recognize that modern tort law trends strongly toward limiting these historical protections, often replacing them with statutory waivers or narrow exceptions. Understanding where these absolute bars still exist is essential for mastering the nuances of tort law principles tested on the bar examination. We begin our detailed analysis with the first historical barrier, interspousal immunity. This doctrine was deeply rooted in the common law concept of coverture. Under coverture, a married woman's legal identity was subsumed by her husband. Spouses were treated as one legal entity. Consequently, one spouse could not sue the other for tortious injury, as the law viewed them as incapable of committing a tort against themselves. However, this concept is now largely obsolete. Modern tort law has seen the nearly universal abolition of interspousal immunity across the United States. Today, spouses can generally sue each other for both negligence and intentional torts, reflecting a societal shift recognizing the independent legal personhood of married individuals. It is vital to note, however, that a few minority jurisdictions still retain limited forms of this immunity. These remnants often apply narrowly, perhaps only shielding liability for certain intentional torts, such as battery, or where the issue of insurance coverage is directly implicated in the claim. For bar exam purposes, assume abolition unless a specific jurisdiction or statute dictates otherwise. Moving from spousal relationships, we now examine parental immunity. Historically, this doctrine shielded parents from tort suits brought by their minor children. The rationale centered on preserving family harmony and protecting limited parental resources from litigation. However, like interspousal immunity, parental immunity has suffered significant erosion. Today, the rule is largely swallowed by exceptions. Key exceptions permit suits for parental conduct involving willful or wanton behavior, which is clearly outside the scope of legitimate parental discipline. Furthermore, immunity almost never applies when the parent is acting in a capacity separate from their parental role, such as when a parent negligently drives a car with the child as a passenger. Many jurisdictions have also enacted statutes that explicitly waive immunity, allowing children to sue parents for ordinary negligence in specific, defined contexts, such as automobile accidents. For bar exam purposes, recognize that parental immunity is now the exception, not the rule. We have now concluded our review of personal immunities, noting how both spousal and parental protections have largely eroded under modern tort law. We now pivot to the realm of governmental liability, where the concept of sovereign immunity holds sway. This doctrine finds its historical root in the ancient maxim, "The king can do no wrong." This principle meant that the sovereign, or the government, could not be sued in its own courts without its explicit permission. For centuries, this provided absolute protection against tort liability. However, just as personal immunities have been curtailed, so too has sovereign immunity. Today, the government's shield is almost entirely statutory. Understanding governmental liability requires mastering the specific legislative acts that waive this immunity, as these statutes precisely define the scope and limits of when the government can be held accountable for the torts of its agents. We now turn our attention specifically to the federal sphere, where the primary mechanism for waiving sovereign immunity is the Federal Tort Claims Act, commonly known as the FTCA. The FTCA represents a broad, though not absolute, waiver of immunity for torts committed by federal employees. Crucially, this waiver applies only when the employee was acting within the scope of their employment. If the employee was on a frolic of their own, sovereign immunity remains intact. However, even when the FTCA applies, plaintiffs face a significant procedural gatekeeper before they can ever step into federal court. This prerequisite is the requirement of administrative exhaustion. Before filing any lawsuit under the FTCA, the claimant must first present their claim to the responsible federal agency itself. This means filing a formal administrative claim, allowing the agency time to investigate and potentially settle the matter internally. Only after the agency denies the claim, or after a specified period passes without agency action, is the claimant permitted to proceed with litigation in federal court. Mastering this administrative exhaustion step is essential, as failure to comply results in the dismissal of the case, regardless of the underlying merits of the tort claim. Having cleared the administrative exhaustion requirement, we now confront the most significant substantive limitation on the Federal Tort Claims Act waiver, the discretionary function exception. Often called the DFE. This exception is crucial because it shields the government from liability for actions that involve policy judgments. If the discretionary function exception applies, the government retains its immunity, preventing courts from second-guessing legislative or administrative decisions. Courts apply a mandatory two-part test to determine if the discretionary function exception shields the government action. First prong. Did the challenged action involve an element of judgment or choice? If a federal statute or regulation specifically mandated the action, then there was no choice, and the exception does not apply. The action must have been left to the discretion of the employee. Second prong. If there was discretion, was that choice based upon considerations of public policy? This is the core inquiry. If the employee was merely exercising professional judgment in a routine operational manner, the exception does not apply. However, if the decision involved balancing competing public interests, such as safety versus cost efficiency, then the choice is deemed policy-based, and the government is immune. Meeting both prongs means the government wins on immunity grounds. Having analyzed the federal waiver under the Federal Tort Claims Act, we now turn to state and municipal immunity, often collectively called governmental immunity. Similar to the federal approach, most states have enacted their own statutes waiving immunity, often mirroring the Federal Tort Claims Act structure. These waivers typically abolish immunity for operational negligence committed by state or local employees acting within the scope of their duties. However, state law often retains historical distinctions that federal law has largely abandoned. Historically, states distinguished between inherently governmental functions, which remained immune, such as policing or legislative acts, and proprietary functions, where the government acted like a private business, which were liable. Operating a municipal water system, for example, was typically proprietary and thus exposed the city to liability. Crucially for bar exam purposes, state statutes frequently maintain broader immunity than the Federal Tort Claims Act. Specifically, many states refuse to waive immunity for intentional torts committed by law enforcement officers or correctional staff, even if the act was operational, leaving a significant gap where the state remains shielded. We conclude our analysis by synthesizing these complex immunity doctrines for bar exam readiness. Remember this overarching theme: the trend in modern tort law is decidedly toward liability, eroding historical protections. Interspousal and parental immunities are now largely historical relics. They survive only in very narrow, specific contexts, often relating to parental discretion or specific state statutory carve-outs. When dealing with governmental liability, understand that sovereign immunity is almost universally waived by statute, both federally under the Federal Tort Claims Act and at the state level. However, the waiver is not absolute. For federal claims, the discretionary function exception remains the single most potent barrier, shielding policy decisions from judicial review. For state claims, watch closely for intentional tort exceptions retained by state legislatures. Success on the bar exam requires memorizing these precise statutory exceptions, as the general rules favor allowing the suit.